Good morning. My name is Denise. I'm a health freedom activist in Northern California. I represent Freedom Angels. We are a group of mothers who stand up. We are patriots. And I am going to read to you a statement that we have created regarding the referendum on Sb714 and Sb276. This referendum would be put on the ballot for California voters to decide if these laws should be in place for our children in California. And it also will describe what the current law is going to be and how it's going to affect you. On September 9th, 2019, Governor Newsom signed Sb276 and Sb714 into law in California. The following day, in order for the California Health Freedom Movement to make the best decisions regarding the option of referendum, we filed referendums on both Sb276 and Sb714 with the Attorney General's office. The deadline to turn in the signatures was 90 days from the date of Governor signing, which was December 9th. We were quickly disappointed to learn that the title and summary provided by the Secretary of State, which is the wording used on the ballot, was grossly misleading. Sb276 was portrayed as a benign law that simply requires the use of a standardized medical form that must be signed by a doctor and may be revoked if determined to be incompatible with CDC, ACIP, or AAP guidelines. Companion law Sb714 states exemptions obtained before 2020 are effective until the next grade span. The next grade span checkpoint, and doctors need not certify exemptions under penalty of perjury. This misleading title and summary statements would inevitably make educating voters to the egregious nature of these laws very difficult. The truth is that Sb276 and Sb714 place barriers so restrictive to the medical exemption process that essentially medical exemptions would cease to exist in California. These laws will have a complete chilling effect on a process already rife with barriers, as doctors will be unwilling to write a medical exemption for fear that a California Medical Board investigation will be triggered and their licenses and good standings will be in jeopardy. Senator Richard Pan sold a bad bill of goods when he assured them that family history and doctor's discretion would be allowed when considering medical exemptions. This is absolutely not true. CDC, ACIP, and AAP guidelines are very restrictive, limited to history of anaphylaxis, encephalitis, or coma from a previously administered vaccine, and only allow for family history in a rare few instances. Even those rare instances would only allow for exemption from one vaccine and potentially on a temporary basis at best. For example, should a child suffer anaphylaxis from a vaccine, they would qualify only for an exemption from that one vaccine. To be exempt from any other of the 9 vaccines currently mandated, the child would have to suffer through and survive an anaphylactic reaction to each of the additional vaccines. Children who have developed seizures, paralysis, autoimmune disease, neurodegenerative conditions, and countless other vaccine reactions will not qualify for a medical exemption, and neither will their siblings. Sb276 has removed the doctor's ability to use their professional discretion to exempt from, slow down, or alter the quantity or timing of the standardized vaccine schedule. In California, children who need a variance from the schedule will be unable to attend private and public daycare, preschool, and K-12 education, as there are now functionally no exemptions at all. The truth is further obscured from the people in the wording of Sb714, which implies grandfathering of existing medical exemptions until next checkpoint. This fails to make clear that existing 277 compliant medical exemptions, should they be triggered for review, are still subject to revocation if they are incompatible with Sb276 narrow guidelines. This means current medical exemptions will be retroactively revoked should they come under review due to SB276 triggering factors or vax extremist vigilantism. After careful consideration, which included consulting with countless others involved in this issue, the decision was made to not proceed with the referendums. The title and summary, as provided by the Secretary of State, the anticipated expense and human capital requirements, the feedback received by members of the health freedom community, as well as the current political climate in California, led us to believe the referendums were not the best option. It is important to note that there were no filing fees and absolutely no money was raised or spent on this effort. Our critics will say the referendum failed, but this is simply not true. After careful consideration and much conversation, we determined a referendum at this time was not the best spend of resources and energy. We would argue that the critics, as well as those seeking to understand and find bold solutions to this complex issue, should turn their attention to the California legislature and Governor Newsom. Their failure, for whatever reason, to conduct due diligence in fully understanding the impact of Sb276 and Sb714 on our state's most vulnerable children will result in segregation, discrimination, and demonization of innocent children based solely on their health status. Our administration's failure is a clear message that California for all is really a California for some. It's California for all except our most at-risk children. For our freedom, for truth, and for our children, we won't stand down. Freedom Angels. Now, what does that mean? That means that there are no medical exemptions in the state of California. We no longer have access to that. We no longer have access to that. Doctors are extremely scared that they're going to come under investigation. And in the wording of the bill, after 5 exemptions per year by that doctor, if they write medical exemptions, they will be under investigation in the state of California. So what happens to a doctor that has a practice that takes care of children who have autoimmune issues, who have cancer, who have degenerative issues? They cannot write a medical exemption, even for those children, unless they are okay with getting flagged by the California Medical Board. This has been a complete overreach of the state. This is the state practicing medicine. And in order for us to start fighting back, we have to get involved with politics. We have to stop allowing the corporate interests to lobby our representatives at millions per legislative session. And we have to start getting involved politically and finding out who these campaigners are, who donates to these campaigns, and what representatives are actually supporting the Constitution and our children in California and all over the nation. It's important to start getting involved. Even if you don't know how to get involved, start joining parents who are lobbying their reps. January 6th, we'll be back in Sacramento for another Occupy. That is the first day back for our legislators, and we will be there to greet them and let them know that we are not going away. We are a grassroots organization that has found our elected representatives have been bought and who have not done their due diligence to look at these laws that are being introduced. January 7th is our first day back lobbying, and we will be there with parent lobbyists, and we will be there in every representative's office letting them know, don't you dare touch homeschoolers, don't you dare touch charter schools, and don't you dare touch children who have IEPs. We're seeing in Southern California, in the inner cities like East LA, the schools are turning away children who have IEPs, saying that the law is gray on the federal level, and all they have to do is provide services, not education. So children who were supposed to be protected are no longer being protected and are being removed from public school because of their health status, which is a clear discrimination and against the Adults with Disabilities Act, and it's being ignored. Our children on IEPs are not protected anymore. Our children who have autoimmune issues are not protected anymore. We're now seeing that hospitals are requiring that children be up to date with vaccines, including the flu shot for transplants. Children who have kidney failures, organ failures, are now being told that they cannot proceed unless they have the flu shot. Where are we in the United States? We have the pharma cartel has their hands in every single legislator, has their hands in every single state, and we're seeing that with New York, Florida, Maine, New Jersey's next. When is enough enough? A pharmaceutical product that has no liability, a pharmaceutical product that does not test against a true inert placebo, a pharmaceutical product that's tested as a biologic, because as a biologic, the standard gold testing is not necessary. Just like they did with the Gardasil vaccine, they tested against aluminum. That is not a true inert placebo. We need to repeal the 1986 Act. We need to make sure that these pharmaceutical companies can be held liable if our children do become injured or do die from a pharmaceutical product that has not been tested the way other pharmaceutical products have been tested, like Viagra. If Viagra was causing heart attacks, paralysis, if Viagra was causing any other type of neurodegenerative disease, it would be pulled off the market immediately. It would be recalled. But because this affects our children, and vaccines are for the greater good, nobody cares. Real children get really hurt from some of these pharmaceutical products, and nobody is held liable. Not the government, not the pharmaceutical manufacturers, nobody. Not the doctors, not the nurses, not the schools. And now we're seeing that schools have health clinics that are coming to the schools because in the state of California, 12-year-olds can consent to medical procedures without parental consent or knowledge. 12-year-olds can decide to go have an abortion, contraceptives, or the HPV vaccine without parental consent. And then what happens if they react? Nothing. Know that in the state of California, under Sb277, there is an amendment called number 11. Know it. This gives a parent the ability to opt out under a personal belief exemption should any other future vaccines get put onto the schedule, like the HPV vaccine, which is coming this legislative session. So if you don't want your child to have that, please be sure to come out on January 6th and 7th and that entire week, except for Friday, because we are going to fight and make sure that these legislators do not touch our homeschoolers, our children with IEPs, do not introduce the HPV or a flu mandate anymore. We have had enough. So to get involved, you can email freedomangels@protonmail.com and know that we are going to do everything that we possibly can to make sure that our children are going to be okay in the state of California. It's time to rise up as a nation. So I'll leave you with that. If you have to reach us, you can reach us at freedomangels@protonmail.com.